Hi, everybody.
Hi, Peter. How are you?
Good, thank you.
Good, thank you.
So, Vishram,
So, Vishram, are you from?
Sorry, I didn't catch that, Peter.
Are you from Exeter?
Are you from Exeter?
And no, I'm actually from WebNI. We're sort of hosting we're the tech provider to the Moot. But I am filling in as the second arbitrator for this round because I think El Sayad is not joining.
Okay, great.
Okay, great.
So we've got Roshni. So we've got Fedar and Roshni. So Roshni, I know you're from Middlesex A.
Yes.
Are you junior counsel this time?
No, I'm senior again.
Okay. Are you the appellant or the respondent?
The appellant.
And Fedar, where are you from?
Good afternoon. We're from the University of Exeter.
Oh, we've got both of you together. Okay, that's great. So who do we have?
So you have me, Feda Al-Jundi, as a junior respondent, and my learned friend, Amir Groves, as a senior respondent.
So Amir, what's your surname, sorry?
Amir Groves, AmirGroves, as a senior respondent.
Great. And then we've got Fatima as well. Lovely. So Roshni, then I think the floor is yours. How are you going to spend your 45 minutes? Is it going to be sort of approximately 10 minutes per person? Or 15 to 20 minutes per person? Is that right?
Maybe 10 minutes.
Great. Off you go.
May it please the court, my name is Roshni Mehreen, and I appear as a senior appellant along with my co-counsel, Fatima Zahra, and together we represent the claimant, Mr. Leith Payne. I shall now provide your honor with a brief summary of the case facts. The facts are as follows. The appellant, Mr. Leith Payne, and the respondent, Ms. Raz Rani, are users of a platform called Clevity where they trade cryptocurrency. YAPL in accordance with the platform's essential terms and conditions of trading. The appellant resides in the Sultanate of Oman and the respondent resides in Dubai and not DIFC. They each employ a computer program Beta and Alpha respectively and engage in algorithmic trading. Alpha purchases YAPL automatically at the best price offered, and and beta is set up to automatically offer YAPL for a sale at significantly inflated price if no other users are willing to sell it on the Clevity marketplace. Due to a glitch in Clevity's software, there was a moment in which users with less than $200,000 were excluded from trading. As the only two users on the platform, the appellant and the respondent, that had cash margin about $200,000, the appellant and the respondent's algorithmic trading algorithms were the only ones allowed to trade. During this time, Beta offered to sell YAPL as it was programmed to do so at a highly inflated price, and Alpha agreed to buy it. The concerned parties were unaware of when the incident took place. Subsequently, the respondent filed a complaint in the DIFC Digital Economic Court asking for a decision that the disputed trade on the transaction between the respondent herself and the appellant was void due to unilateral error. The court found in favor of the appellant, Ms. Ras Rani. The respondent now appeals to the Court of Appeal on 2 grounds. I will now address Your Honor on the first ground of appeal, namely that the presence of Clevity's node within the DIFC server does not give DIFC jurisdiction over the disputed claim. I now make submission 1. Clevity's node in DIFC is not the site of transaction. A node determines legitimacy of transactions and furthermore saves and stores transactional history. Judicial Law Article 5A, Section 1, Subsection B requires that contracts that are concluded, finalized, or performed within DIFC will allow it exclusive jurisdiction. But as stated earlier, neither of these acts could be fulfilled by a node. However, there are other requirements that could be met by a node in DIFC that will allow it to determine jurisdiction. In the case of Ion Science Limited and persons unknown, cryptocurrency has been considered a property as per the High Court of Justice, Business and Property Courts of England and Wales Commercial Court. With cryptocurrency being viewed as an asset or property, it can be subject to usual property laws, one of which is the concept of lex situs, in which assets in question are subjected to laws of the state in the location of the asset or where the person who owns them is situated. A node does not hold or store the cryptocurrency itself. It is simply a record of transactions. Thus, its presence or absence in DIFC cannot satisfy the criteria for the application of lex situs. And in the application of the latter criteria, the respondent's area of residence is not the DIFC, which is an independent jurisdiction, rather it is Dubai. Dubai courts have regulations on the matter of virtual asset law, law number 4 of 2022, the virtual asset law, and the Dubai courts are much capable of handling the case at hand. There are other criteria which when satisfied could allow a certain state jurisdiction over the dispute. The central management and control test as established by Lord Lober in the case of De Beers Consulate Mines Limited and Ho sets out 2 requirements for jurisdiction, that it must be a location in which actual business takes place or the company resides for income tax purposes. These requirements cannot be fulfilled by a platform like Clevity, which has multiple nodes, and since nodes are merely devices authorized to keep track of the distributed ledger and serve as communication hub for various network tasks, it is not the location of transaction. And therefore, it is safe to say this business does not take place in the node located in DIFC. And given the vast number of nodes a platform generally has, it cannot be held that a node represents a company's residence, since that would allow multiple state laws to dictate matters of the cryptocurrency, and that would simply be unreasonable. I now proceed with the second submission to further establish the points made earlier. An establishment can determine jurisdiction. However, since the node in DIFC is not an establishment, its presence or absence does not impact jurisdiction in the case at hand. Regulation 44 of 2001, Article 5, Subsection 5 sets out that an establishment may establish jurisdiction. Essential characteristics and elements need to be satisfied by a body in order to be considered an establishment. The first requirement is that it must be an extension of the parent body in carrying out its main purpose or aim, in this case, carrying out transaction. Another element of the establishment is its appearance of permanence and a representation of legitimacy. And since a node can be downloaded by any capable person, therefore to be tied to the idea that a node is a representation of the company itself could be misleading. In conclusion, a node can neither satisfy the requirements of an establishment, nor can Clevity prove its location of residence as DIFC. Therefore, the presence of Clevity's node in DIFC cannot be a justification to grant DIFC jurisdiction. I'm unable to hear you.
Good point. Thanks, Roshni. Looking at your skeleton at paragraphs 12 and 13, so you've mentioned tulip trading. Now, in support of the proposition that the location of the company's residence determines the jurisdiction, who are the parties to this dispute, and are they companies? The parties to this dispute, I think, are Miss Razi, and Mr. Payne, who are individuals. Could I distinguish Tulip from the present situation by saying that Tulip concerns legal persons, but the current dispute concerns natural persons? Or is that a weak argument?
I was trying to make the association that Clevity's lack of residence does not give, like, the Clevity as a company is the comparison I was trying to make, not the appellant and the respondent. Like, Clevity does not reside within DIFC, so how can?
Well, that's a good question. So I think we've sort of got a three-way contract, don't we, between
Yes.
Miss Rani, sorry to keep calling Razi, Miss Rani, Mr. Payne, and Clevity. Now, we don't know whether or not the standard terms and conditions of Clevity impose a particular jurisdiction if they've opted into a jurisdiction for their disputes. But we do know, well, they sort of fall out of the picture, don't they, in this dispute? Because really the disputed trade is it's a contract that's formed between the claimant and the defendant for the sale of a certain amount of cryptocurrency.
I'm sorry, I wasn't able to hear.
Isn't the contract really just between the claimant and the defendant for the sale of cryptocurrency?
Yes, but like most of the case law suggests that in the matters of jurisdiction, they do take into consideration the residence of or the location of the actual cryptocurrency itself.
I mean, the problem is that these jurisdictional rules come from different court systems. So in Tulip and in De Beers, they're both English cases, and so is Iron Science. And England's courts have got different rules over their jurisdiction than the DIFC courts do. So that's why I think those authorities are of limited use. But well done, anyhow. Could I ask who from Exeter is senior counsel for the respondent? It's Amir, is it?
Yes, Your Honor. Can I just confirm if you can hear me, please?
I can.
Yeah.
Off you go.
All right. Good evening, Your Honor. If it pleases the court, my name is Amir Groves, and I'll be acting as senior respondent, and I'll be appearing with my learned friend, who will be acting as junior respondent, Mr. Fadal Al-Jundi, on behalf of Mr. Rani. Your Honor, I'm sure you're familiar with the facts of the case at hand. My submission will concern the first ground of appeal, which relates to the DIFC jurisdiction. Your Honor, the first instance court was successful in concluding that Clevity operated a distributed ledger with a node within DIFC. The court had jurisdiction over the claim presented by Mr. Rani against Mr. Payne. This is shown within Article 5 5A1B of the Judicial Authority Law, which can be referred to on page 14 of the Respondent's Bundle. This reads, Your Honor, civil or commercial claims and actions arising out of or relating to a contract or promised contract, whether partly or wholly concluded, finalized or performed within the IFC, or will be performed or is supposed to be performed within the IFC, pursuant to express or implied terms stipulated in the contract. Your Honor, the judge of the First Instance Court relied upon this article because of the statement relating to the transaction being categorized as partly or wholly concluded, finalized, or performed within the IFC. Your Honor, the word I would like to emphasize within that statement is partly, which validates the jurisdiction over the transaction between both parties since it falls within the criteria and follows the legislation at hand. In addition, showing the quantity of the transaction within the contract being irrelevant for jurisdiction to be present within the IFC. This can be further supported with the information that is present that Clevity had, quote, one such node on a server based within the IFC, end quote. This is sufficient enough to apply Article 5A, subsection 1B, because of the use of wording allowing for a more generalized acceptance of what can constitute a jurisdiction being established within a dispute. Your Honor, a blockchain node can perform a lot of different functions, such as validating, rejecting, or legalizing a block of transactions. Confirming its legality of a block of transactions, which indicates it is participating within the contract. However, Your Honor, the parties, Ms. Rani and Mr. Payne, were both trading on a singular platform, whereby they entered contracts with the use of their algorithmic programs to purchase Yapple at the best price available on the market and sell Yapple at the average in relation to the market at a certain period of time. The logical argument would be that the node is registered within the IFC. This can be inferred because it is located within a free zone in Dubai. Implicating business activity is present within the IFC, which can be related to the case of Al-Khurafi v. Bank Sarsen. Therefore, Your Honor, the claim of contract not being negotiated is rejected. If I can refer you to paragraph 36 of the case of Al-Khurafi, which can be seen on page 9 of the Respondent's Bundle, it stated that the court is given jurisdiction where there has been relevant activity with regard to the contract or related to within the DIFC. Relevant activity is present in our case as the node within DIFC is completing transactions which are being sent from the user within the app of Clevity, who are geographically based within Dubai and are near the DIFC area for the DIFC node to recognize. This rejects the idea that the transaction should be wholly performed within the IFC. This is further supporting with the quoted relevant activity will suffice for DIFC. This is further supported with Article 5A1B of Law Number 12 of 2014 and the case law present, showing it is apparent that the quoted relevant activity will suffice for DIFC to establish jurisdiction within the situation between Ms. Rani and Mr. Payne. To conclude my submission, Your Honor, DIFC did indeed have jurisdiction within the situation between Ms. Rani and Mr. Payne. Now to follow along with my learned junior respondent with the second ground of appeal. Your Honor, your mic is...
Yeah, we've got a node based in the DIFC. And there are, I don't know, hundreds, thousands of these nodes based around the world. Do we know for sure that the transaction was processed through the DIFC node?
No, we do not know for sure that it was processed within the DIFC node, but we can assume that if one of the customers was based within Dubai, that it was partly in use during the transaction.
Okay, yeah, that stands to reason. Again, it's an assumption, but it's a reasonable one. Can I ask, if you and I were talking and I was going to sell you my car, and we just, neither you nor I live in the DIFC, we've got nothing to do with the DIFC, but we just happen to walk through the DIFC while we're negotiating the terms of the contract, and then we walk out of it, and we fall into disputes, and someone brings a claim to the DIFC courts. Don't you think that it's a mere contingency that we just happen to be in the DIFC at the time? Is it fair?
It is, you could say they would have jurisdiction over that contractual agreement if it is agreed upon, because you're coincidentally walking through DIFC areas and deciding to enter a contractual agreement, whereas the node is actually placed there to facilitate transactions being completed through the Clevity app.
But let's get it. Is it fair? Because I mean, I can see that Razrani has called Miss Razi in the instructions. But anyway, the claimant and the defendant have got nothing to do with, or the appellant and respondent have got nothing to do with the DIFC. I mean, one's based in Dubai, the other one's in Oman. The DIFC court is an English language court. It applies DIFC law, whereas alternative courts like the Dubai court or the courts of the Sultanate of Oman, they would apply a more similar law, civil law, probably quite similar to each other, one under the Sharia anyway. Given the nationalities of the parties, given their domicility, wouldn't it be better to have this in one of the civil law courts under civil law? Why the DIFC?
I feel it wouldn't be beneficial to have it in the civil courts, and I feel the DIFC could have better jurisdiction over this. Because they have a global understanding of legislation which can be applied.
Yeah.
And they are, so DIFC follow their own legislation and follow their own law. And within Article 5, it said even if a contract is partly concluded or finalized or performed within the DIFC, it would conclude that it has jurisdiction over that contract.
Okay, so it's the mandatory language of Article 5 that you're reluctant to get out from. Okay, that's great. Who's going next? Well done. Do you guys want a break for 5 minutes before we move to the next speakers, or should we just plow on, because we've only taken 25 minutes so far?
Yeah, well, we can continue on. If that's
okay, I think Fatima, I think you're next.
All right. Good evening, Mr. Smith.
Hello.
So my learned friend Roshni Mehreen Syed has already established to the court that the presence of Clavity's node in the DIFC does not allow it jurisdiction to adjudicate the case. If the court will allow it, will now present the second issue. The facts of the case have already been expertly laid out for your convenience by my senior. Therefore, I will move on to make my submissions. Our second ground is that the judge erred in concluding that a unilateral mistake occurred in the disputed trade and that a reasonable trader with knowledge of the transaction would not continue on with it. Consequently, the judge erred in concluding that Article 37, Section 1, subsection A was satisfied. I submit that it was established in the case of Quene PTE Limited and B2C2 Limited, which was the second case decided in 2020 in the Singaporean Court of Appeal, that if an algorithm is programmed to make an offer based on an external order it received, and another is programmed to accept as long as it fits into the certain parameters set by the owner, then the contract is considered to be between two consenting parties. Here, the court shares the view that the automations are simply extensions of the human mind. The principle was established in Thornton and Shoe Lane Parking, reported in the second volume of the 1971 Queen's Bench Division Report on page 163 by Lord Denning. In his judgment, he even goes as far as to compare the ticket machine to a booking clerk in disguise. Your Honor, this further accentuates the fact that any transaction between a machine and a man is a contract between the owner of the machine and the man, and as per the standards of fair trading, both parties are expected to keep the end of their bargain. It is therefore a viable conclusion that according to Article 37, Section 2 of the IFC contract law, that the conditions for unilateral mistake are unmet, since my client insists that there was no mistake on his part when it came to programming his algorithm. And with the legal principles set in Quine, the automation, as with the owner, should have presumed the risk of mistake that would possibly occur in the world of crypto trading. In conclusion, the conditions for unilateral mistake to exist under Article 37, Section 1 of the IFC contract law are not met, and the contract between Mr. Payne and Ms. Razi remains valid.
Thank you, Fatima. So, I think I said before that I think 37(1)(a) is a really hard piece of, or Article 37 overall, is a hard piece of legislation to get to grips with. And we really ignore Ms. Razi, so 37(1), the party who wants to avoid the contract for mistake. We ignore the reasonable person in the same situation as the party. We ignore that bit. But 37(1)(a), we look at the other side. We look at what the other party, Mr. Payne, knew or ought to have known of the mistake. Now, the question is, what test do we apply when we say he ought to have known of the mistake, or that he did know of the mistake? Do we say, okay, let's create a hypothetical model of a reasonable trader with knowledge of the circumstances surrounding the transaction? Or do we actually look, and we might call that the objective test, or do we actually look at the subjective state of mind of the programmer when designing the program? Now, as I understand it, your argument is that we should reject the reasoning of Lord Mance, and we should go for the Singapore Court of Appeal majority and the decision of the court, the first instance Singaporean court in that case, and we should consider what Mr. Payne in fact knew of the mistake. Is that right? Or should have known of the mistake?
Sorry, can you repeat the last sentence?
That that the DIFC court in this dispute, in this hearing now, I should ignore what the court of first instance did, where it said that the reasonable trader with knowledge of the circumstances is the test. We should ignore that, and we should instead look at Mr. Payne's mind when he was designing the program. Because do you say that's fair? Do you say that's reasonable? What are the arguments in looking at Mr. Payne's mindset? I mean, the point that Lord Mance is making in his judgment, and again, everybody, I accept it's a difficult judgment to get to grips with, but a point he's making is that no programmer in the case like this is ever going to say that my algorithm would have spotted the error or should have spotted the error. Because when you've made loads of money by creating a program to trade on your behalf, and it makes you lots of money, you're never going to say, okay, look, I accept it was a mistake, are you? You're never going to say that. Mr. Payne would never provide evidence that he knew or ought to have known of the mistake.
Can I answer that?
Yeah, please do. Yeah, go on. Yeah.
So my defense to what you're saying is that the whole the profit-making idea of this industry of crypto trading is purely based on these mistakes, as they call it, as they happen. So they are relying on fluctuations and sudden changes to make profit. So to assume exactly the standards of fair dealing that we would have for, say, two human parties that are existing in this, has a state of mind during each and every stage of the contract making, to assume those same standards for algorithm trading is unreasonable, I would say, because the whole point of this industry is that you benefit from fluctuations, and you trust your programming and you depend on it, whatever the scenario, whether it fails you or it is whether it fails you or benefits you. I guess I haven't made this analogy in my skeletal argument, but I would actually compare this with the stock market. You cannot reclaim the money you lost investing. So assuming it's the same risk of trading, I don't think it's, right to apply the same standards.
Okay, no, and I agree with you. And the draftsman of Article 37 agrees as well, because Article 37 is a hard mistake. Basically, sorry, a high threshold. Basically, you get mistakes where both parties agree that there's a mistake, and that's normally what happens. In this case of unilateral mistake, one party says, oops, I've made a mistake, and that's Miss Razi's position. And the other side, Mr. Payne says, no mistake was made at all. The parties produced these programs, they interacted, and it was within the realm of the possibility of the contract that was between them about this trading of this cryptocurrency, Yapple, that the disputed trade could occur, or should I say the profit, the enormous profit that Mr. Payne made under the disputed trade could occur. The thing is, I think it still lies. I mean, you've argued about fairness in this interaction, but it still lies. I think the position still is that Mr. Payne would never provide information of his mindset, which would show that he didn't know, or he ought to have known of the mistake.
But Mr. Payne did provide evidence of his mindset.
Where's that?
Because in all the cases that are mentioned, what is happening is that the programmer is giving excuse me, can I just rephrase my sentence?
Yeah.
So what I'm trying to say is that the state of mind is, instead of the state of mind that the courts evaluate, instead of it being present for each and every transaction, because of the invention of the algorithm trading, the state of mind that the programmers had immediately when they made the program is what's being applied for every trading. And that is a risk that unfortunately all traders will have to deal with.
That's true.
So he did not make a mistake.
No, and I think actually I see now that in paragraph 8 of your instructions, Mr. Payne said that even if Miss Razi had made a mistake when he programmed better, he did not make the same mistake as Miss Razi, of course.
Exactly, that's the one.
He did not know and could not know about Miss Razi's mistake, and there could be no grounds to avoid disputed trade. Okay, well done. And then Fedar, would you like to go ahead now?
Yeah, sure. Thank you for giving me the time to continue. I'll be continuing the submissions on behalf of the respondent, and we'll be moving to ground 2 of our submissions, which is the mistake.
Yeah.
Your Honor, it's our submission that the learned judge was correct in concluding that for the purpose of a claim to avoid the dispute trade, it was sufficient for the purpose of satisfying Article 37(1)(a) of DIFC contract law that a reasonable trader with the knowledge of the circumstances surrounding that transaction would have concluded that the dispute trade was the result of an error. May I direct Your Honor's attention to page 12 of the respondent's bundle?
Yeah.
In page 12, Article 37(1)(a) of the IFC Contract Law 2004 gives the court and the common law, or allows the court to interpret the law in order to develop it, i.e. they can say or alter the law to keep pace with changes in commercial contracts. So a reasonable trader with the knowledge of the circumstances surrounding the transaction would have concluded that the dispute was the result of an error. This goes to show that any trader with the knowledge of the parties would have assumed or expected a risk of mistake when trading in such an unpredictable market such as the one we have in our case. The error here has occurred as a result of a failure in the system, which is a third party involved, namely Clivity. Additionally, the same article 37.1a mentions the word fair dealing, which can be interpreted as the general concept of goodwill, in common contract law, and the appellant's client did not have goodwill. They programmed the computer to take advantage when programming of our client when programming his computer, which is to sell at an inflated price, which is contrary to the goodwill principle. Moving on to our next point, which is reliance on Lord Mance's reasoning in paragraph 201 of the case of Quinn Private Limited versus B2C Limited, which was correct. And one of the reasons for this is that the transaction if this transaction was to take place between the two parties in person, it would not have been concluded, as the price was, and I quote from the case, 250 times higher. Your Honor, so no reasonable person with the knowledge of the parties would have agreed to it. This means that unless it's a mistake, no reasonable trader would have agreed to this transaction. Lord Mance went further to say that no trade would ever take place at the deep prices which had programmed his computer to output the platform at apparently random times other than as the result of some fundamental error. Your Honor, let's suppose that this transaction was to be concluded in person by both parties. The answer for this would be that it would never be concluded, as Lord Mance again mentions at paragraph 182 that no human trader agree to the result of some fundamental mistake, which led to the terms of the sale. May I please direct your attention to page 13 of the respondent's bundle. The court in our present case and the case of Quinn Private Limited versus B2C Limited did not apply the case of Deputy Commissioner of Taxation versus Chamberlain. This is an Australian case which has been used to prove that there was an apparent mistake as to pricing, and a reasonable trader would have determined that. In this case, the court found that by acting with extraordinary haste to accept the incorrectly assessed tax liability, an operative unilateral mistake had been caused by a typing error, and that the settlement was therefore void in equity. The mistake in our current case is fundamental to the point that the entire transaction relied on it, and therefore, and I quote, but for that mistake, the transaction would not have concluded, and the price would not have been inflated. This shows that the court of first instance was correct in relying on Lord Mance's reasoning in the case of Quinn Private Limited versus B2C, as the transactional problem was also mistaken as to the premise in which on which the buyer order was placed. Your Honor, pricing mistake diminishes algorithmic trading core principles of trying to profit from price differences between buyers and sellers by executing trades quickly. Such errors have actually occurred with stock exchanges. However, these stock exchanges have regulations and rules in place to cancel these trades when pricing errors are brought to their attention as a result of computing errors. Similarly, the British Columbia Supreme Court issued an order to track cryptocurrency transferred made in error in the case of Crypto Track Private Limited versus Wall in 2018. And therefore, the court of first instance was correct in concluding that there was indeed a mistake, and it should have been rectified as that transaction was concluded in a similar manner to our current case. Your Honor, for the reasons that have been put forward by myself and my senior respondent, it is our submission to the court that it should uphold the decision of the court of first instance due to the IFC having jurisdiction and due to the existence of relevant mistake. Your Honor, unless I may be of further assistance to the court, that concludes my submissions.
Well done. Yeah, and good to see some argument by analogy in there as well. Did you think that there is a model of a reasonable trader with knowledge of the circumstances surrounding the transaction? I mean, all of these man on the Clapham omnibus tests, they require a degree of what's called hypothecation. You just have to, judges sitting in their court have to think, oh, well, you know, if I was Mr. Payne and I was a reasonable trader and I knew what Miss Razi had done, then I would conclude that it was a mistake. Do you think that's, I mean, that's an artificial exercise, isn't it? And also it flies in the face of actually what Mr. Payne said at paragraph 8 of the instructions about his own knowledge.
It appears from the facts and what both parties knew that this wouldn't have been concluded in person again, Your Honor.
Yes, but I mean, it seems grossly unfair that the judge now just sort of creates this reasonable person test and tries to guess what that person would have concluded had they been there, when in fact the evidence seems to be contrary. I mean, can you think of any other examples where a reasonable person test is applied? Why should I prefer that over subjective knowledge?
I think in the case of Moot and I'm trying to remember the name of the case, Your Honor.
That's
could
okay,
be murder cases that could be applied, which is very not relevant to our current problem, but murder would be applied.
In murder, is that right? I think maybe it's something like self-defense as defense to murder. I think we say
assault, like a lower threshold. Assault would be suitable, I think.
Yeah, and it's along the lines of, did the person who claimed self-defense, did he, would a reasonable person in that position have acted the way he did in acting in self-defense? And also, did the defendant try and act in self-defense, knowing, you know, the circumstances of his position? But that's a criminal case. This is contract. You know, Miss Razi and Mr. Payne are both relatively sophisticated cryptocurrency traders. They're both trying to make money by creating sophisticated algorithms and getting online.
Yeah.
So I don't think the court should have much sympathy with Ms. Razi.
Well, I think the contrary, Your Honor. I think they should have sympathy because one of the traders, which is Mr. Payne, that what they did was against the actual logic of trading and fair dealing, and they went against that by programming the computer to actually take advantage of my clients of the error that was occurred, not as a result of my client's error, but as a result of third party. So to summarize the point, what I'm saying is Mr. Payne took advantage of the error that was created as a failure in the system by a third party.
But we know now it was an error, but when he designed his computer program, the circumstances which arose, he didn't interpret as being an error. He said, if these sorts of crazy things happen, then computer program, you respond accordingly. He doesn't care about the intention of the counterparty. You know, the computer programmer could have thought that Miss Razi intended to do what she did, couldn't it? Or what impact do you think the amendment to Clevity's software has on that sort of analysis and where the balance of justice is?
Sorry, can you point out which amendment, Your Honor?
Paragraph 5 of your joint instructions, it says that Clevity's software underwent a routine upgrade. As a result, there was an error.
Yeah.
So why do you think that tips in Miss Razi's favour, or do you think that it's still, well, Miss Razi contracted with Clevity, she entered the platform knowing that there was a degree of risk in what she was doing, and this falls within the scope of that risk?
I wouldn't say she knew that an error would happen and she would be a victim of a third party failure because someone else on the platform programmed the computer to take advantage of people like her in such situations. So I wouldn't say that she assumed a risk or an error. as it wasn't
Okay.
created by her.
Well done. And then Fatima, do you have anything to say in the end? Are there any points you want to make in response?
Grateful, Your Honor.
I would just once again like to reiterate the fact that goodwill and standards of fair dealing cannot be assumed for any transactions made in this industry.
Yes. Yeah, I agree. I mean, it's a commercial transaction. Parties seem to be making livings out of it. And again, yeah, they're sophisticated if they're doing their own computer programming for algorithmic trading. They're not, elderly people investing their pension trying to make a small amount of profit. Does anybody have any other points they want to raise?
No, Your Honor. We're grateful for the time that have been given.
No, brilliant. Well done, everybody. I'll fill in the form. I was making a few notes, and I'll send it to the organisers. And very best of luck. Yeah.
Thank you, Your Honor. Would you like to provide any feedback, as some previous sessions they did?
You all spoke very well. I think these both grounds of appeal are hard, and I think they are. I mean, the first ground of appeal. There are other ways you can argue this. For example, you guys might want to Google forum non-convenience, and the idea that even if the mandatory language of Article 5 applies, because, as you point out, it seems fairly clear that the node is in the DIFC and that it's highly likely that part of the contract was performed or concluded or negotiated or whatever within the DIFC. Nonetheless, it's more convenient for the dispute to be heard elsewhere, because other than that, it's got nothing to do with the DIFC. Parties are outside the DIFC. They didn't intend to be in the DIFC, and so on and so forth. So have a look at the what's called forum non-convenience side of it. And then on this close reading of Article 37, I think that, the best thing to do overnight is to read again paragraphs 189 to 201 of the Quiono, or was it B2C2 judgment, and try and see the distinction between objective and subjective reasoning in there, which I think is what it's all about. And then consider again just that very narrow part of Article 37(1)(a), which is whether or not Mr. Payne ought to have known about the prospects, the risk of the thing happening, of the error. Okay, it is very difficult, but well done, everybody. And I hope that's it for the day.
Thank you.
Thank you, Your Honor. Have a good day.
Have a nice day, Your Honor.
Thanks a
Thank
lot.
you.
Thanks, everybody. Bye.
Thanks, everybody. Bye.